Good evening, everybody. Hello. Thank you for becoming a subscriber to the channel. We hit 9,000 subscribers this morning. My lordy, I woke up and I couldn't believe it. I was like, oh my lord. When I woke up, I was at like 8,999, y'all. And I was like, ooh, so close. But we made it. We made it over that 9,000 hump. Now we're just like smooth sailing into 10,000, I hope. So it's really nice. So I really appreciate that. I appreciate you guys being here tonight. I appreciate you guys being here this morning or this afternoon. If you missed this afternoon's live, we did go over the probable cause affidavit that was released for the Harmony Montgomery case. Very heartbreaking. I didn't end up eating after I got off the live. That's what I was getting off the live to do, and I couldn't even eat. So if you don't want to ever eat again, you can listen to that live. But no, I hope that her so-called father gets everything that's coming to him. But we are going to be talking about Idaho. So I was going to come back on and do a video tonight for Idaho, and I was like, oh, it'll just be easy peasy, watch a video. Well, then I got on the State of Idaho website just because I was like, I should look on see if they have anything. So I refreshed that page, and lo and behold, like 6 new documents came out. But one of them in particular, the other ones are just, blah, blah, blah. But the one in particular is like 31 pages long. If you didn't think that I got sick of, reading today after the 43-page affidavit, I didn't. I decided to come back and read 31 more pages. But this is really good. This is going to be all about the DNA, how they collected the DNA, how they matched the DNA. They didn't just match the DNA through genealogy databases. They really, really did their due diligence. They've been doing their due diligence, guys. And I saw your email, Jan, right before I clicked on here and I said, no, man. And then I saw Jan emailed me. I saw the email, but I haven't even checked my email yet. I just saw it on my phone and I said, oh, I bet that's the documents. Hello, Jack. Hello to everybody in the chat. Hello, Cheryl. Hello, Sarah, Marissa. I saw Kaylee, Kathy, Summer. All of y'all are here. Everyone's here. Tony, everyone's accounted for. Princess Meg, Elsa, Kaleida Hope. I love that name. I really do. Margot, how you doing, Margot? Bridget's in here. Farrah, I saw her in here. Farrah's like, oh, this is getting good. Alicia, she said, you talked to your mom today. That's so sweet. I wish I could talk to my mama. Actually, I don't know. She might be yelling at me. I don't know. Just kidding. Hello, Terry. Hello, Nancy. Yeah, she'd be very proud of me right now. She'd say, oh, my Lord, how did you get that many people to listen to you talk? And I said, I don't know, Mom. I just did. It's good to see everybody, though. Hi, Aquateal. Hi, Elbeam. But it's good to see everybody. I'm so glad the night crew's rolling in. We had a little bit of a day live today. So if you're not set up for all notifications, you can always hit the little bell icon. And then if you don't get alerted and you're using a cell phone, it's because you might not have your alerts on your notifications like through your cell phone. So just a little heads up. We'll go ahead and get into the documents though, because they are, like I said, a little long. As we're waiting on people to come in, if you guys wouldn't mind hitting the like button, subscribe to the channel, all that good stuff. We'll be coming up on our year anniversary here before even too long. It's in September, but I was looking at it today. Let's see. I'm trying to think of... There we were. I was like, where were we last time? Wow. Okay. And I do have, so we had part 1 of we were going through the probable cause affidavit, and I did part 1 and then I did a video, like a shorter video version of that as well, if you guys want to check it out if you haven't already. That way we all have a visual. Well, the second part of the PCA is a lot harder to get visuals for, so I'm working really hard trying to put all the pieces together for you guys, so it's a little bit easier to understand too. So it'll be just a couple days, but I'll have that out. And then I figured tonight, if we don't get to the video, we'll just get to it tomorrow. So I hope everyone's having a good day. These are just going to be like, the silly back and forth that they're having. So amended motion to stay proceedings. And this is what they've been talking about back and forth the last couple of motions we've heard. They've been talking about the motion to stay. Because there's, Bryan saying he hasn't got enough time to have the evidence. The prosecution saying, they need more time. So they were going to agree to stay the proceedings. But then they came back, and I think that they said they didn't want to stay the proceedings, the prosecution side. So we'll see what they say now. Comes now Bryan C. Kohberger, by and through his attorney, Ann C. Taylor, public defender, and hereby moves this court to stay all proceedings in this case pursuant to Idaho Code 2-213. It says procedural background. Let me know, make sure you guys can see it okay. Mr. Kohberger was indicted by a grand jury on May 16, 2023. He filed a motion to make available the record of all proceedings of the grand jury pursuant to ICR 62 and a motion requesting release of grand jury materials under qualified protective order on May 19, 2023. The state then filed their state's response to defendant's motion regarding grand jury record and transcript and a proposed order on May 30th, 2023. The parties are not able to reach agreement regarding the release of grand jury materials in further opposition of Mr. Kohberger's motion for the preparation of grand jury records on June 6, 2023. The state filed their state supplemental response to defendant's motion regarding grand jury record and transcript. A hearing is scheduled for June 27, 2023 to argue this contested matter. Mr. Kohberger stood silent at his initial arraignment to preserve his right to contest the indictment. He also asserted his right to a speedy trial pursuant to the United States and Idaho constitutions. Jury trial is scheduled to begin October 2nd, 2023. Time is of the essence. Hold on one second. I'm going to have... By the time this court it says argument here. By the time this court hears argument of the preparation of the grand jury proceedings, almost 6 weeks will have passed from the time of the indictment. Preparation of the grand jury record will then take additional time. Mr. Kohberger has the right and intends to contest the indictment. Idaho Code 2-213 allows the defense to seek a stay of proceedings within 7 days after the moving party discovers or by the exercise of diligence could have discovered the grounds therefore, and in any event before the trial jury is sworn to the case, a party may move to stay the proceedings and in a criminal case to quash the indictment or for other appropriate relief on the ground of substantial failure to comply with this chapter in selecting the grand or trial jury. Mr. Kohberger seeks to stay the proceedings as appropriate relief while the matter of the grand jury record is argued and prepared. He is exercising due diligence to discover the grounds upon which to file a motion to dismiss related to how the grand jury was selected. He is being delayed through no fault of his own. Conclusion, Mr. Kohberger requests to stay proceedings until the grand jury record is prepared and he has adequate time to contest the indictment should be granted. The remedies allowed in Idaho Code 2-213, Section 3 are the exclusive means by which a person accused of a crime may challenge a grand jury on the grounds that the jury was not selected in conformity with this chapter. A stay of proceedings is appropriate. So that is the first document there. And I'm going to grab a drink real quick. I'm sorry, guys. I need some water. I'll be right back. Okay, thank you guys. I had to grab some water. And it's in a wine glass. It's kind of funny. Would you like some wine or some water in a wine glass, Paul? And thanks guys for being here. I appreciate it. We're going to get to the, I guess as harsh reality would say, the meat and potatoes here in a minute. We're just kind of getting the 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 few documents out of the way that are the shorter ones. So just kind of going in order. Okay, so this is going to be the order to file defendant's exhibit. And it's just one little page. So the court, it says order to file, let me blow it up for you guys and myself too. Order to file defendant's exhibit C attached to the defendant's fourth supplemental request for discovery under seal. The court having before it the defendant's stipulated motion to file exhibit C attached to defendant's fourth supplemental request for discovery under seal and good cause appearing now, therefore, it is hereby ordered that the defendant's exhibit C attached to their fourth supplemental request for discovery shall be filed under seal pursuant to I.C.A.R 32 I2D, sections D and E. And then it says sections, or IC 74-124, sections B and C. So, if you guys wouldn't mind, while I got you all here, before we get to the real good document, and I'm going to be reading for a while, if you guys wouldn't mind hitting that like button, just taking a second to smash that like button, it really does go a long way. Helps bring more people into the chat, and it'll bring more people to the case, more aware of the documents that are out. So I think everyone knows the case, but they don't know the documents that are out. Hello, Eddie. Hello, Justice. Hello, everybody. Hello, Arlene. Hello, Nancy. Oh, actually, let me get back on the thing so I can see the chat. There we go. So we're going to go to the next one here. That was just one page. So this one is this is the long one, I believe. Oh, wait, no, maybe not. Maybe just one more short one. I always feel like I'm going to miss one. I think I hold on. I think I did. Maybe I didn't. Let's see. Order to file defendants. Okay. Okay, this is the long one. So basically, you guys we're all going to hear, like, I read through this earlier, and I was like, whoa, you know? I was like, I didn't know that. I didn't know that. I've never heard that. So these are things that we're going to hear. You're going to hear things tonight that you didn't know. So we can all agree on that. We're all going to agree on that. This is going to be, okay, so there's like little nuggets of really good information in here. And then a lot of it is just the way that they kind of collected and the DNA and the genealogical part of it. And it's just, it really puts it together in a tight little present and a little gift with a little bow. And it's literally delivered for us. Kind of how they got his DNA, where they found it, exactly what it was, where it was sent to. A lot of people are saying, well, it's supposed to be sent to some place in Texas. I'm going to say Moscow PD never said that. That was old dude that writes writes like fiction or nonfiction or whatever his name. Like, you know, Howard Bloom. That's what I was trying to think of. Howard Bloom. So that wasn't the Moscow police. So I just want to put that out there too, because I know that'll probably come up. So this is motion for protective order. Now comes the state of Idaho by and through the Latah County prosecuting attorney and respectfully moves the court for a protective order pursuant to ICR 16-1 for information related to investigative genetic genealogy. This case arises from a quadruple homicide. Law enforcement found the DNA of a potential suspect at the crime scene, and the FBI submitted the DNA to one or more publicly available genetic genealogy services to determine potential relatives of the suspect. The FBI then used common genealogical techniques to develop a family tree leading to defendant. The state seeks to protect from disclosure the names and personal information of hundreds of innocent relatives on the family tree. The names of the public agree genetic genealogy services used and certain other information described below. The disclosure of this information is not required by Rule 16 of the Idaho Criminal Rules and should be protected from disclosure for the good cause described below, including state's privilege to protect the identity of informers as described in Idaho Rule of Evidence 509. So basically they're just trying to, protect the people that put their DNA into this database where they, ended up using their DNA for this case to track Bryan back through his family tree. So then we're going to go through the factual background. And it says, and whenever we get to something that's like I haven't heard before, I'll let you know too. But hey Wizard Vault, hey Paul, I just happened to look down. Hey Sally Mae, if I missed you, I'm sorry. I happened to get a chance to look down. On November 13th, 2022, law enforcement found the bodies of Madison Mogen, Kayla Gonzalez, Xana Kernodle, and Ethan Chapin at 1122 King Road in Moscow, Idaho. All 4 victims died from apparent knife wounds. Law enforcement found a K-bar knife sheath on a bed next to the bodies of Madison and Kaylee. The sheath was face down and partially under both Madison's body and the comforter on the bed. So we didn't know that before. We didn't know that it was face down. We didn't know exactly. We knew that it was, okay, so when I described it to you guys, actually I have the PCA right here. Okay, because when I described it to you guys, I described it like that. I was like, I think that it was half underneath Maddie's body and then half of it was like on the bed comforter or whatever. I was just going to see how they described it in the PCA real quick. So right here, they said, I later noticed what appeared to be a tan leather knife sheath laying on the bed next to Mogen's right side. So yeah, so whenever we read that, it said that it was by her side, but I kept fighting that and I kept saying, I think it was partially under her. And I was like, I don't know why, I just do. So, so the sheath was face down. So that means it was like the buckle was face down and partially under both Madison's body and the comforter on the bed. So what I'm thinking is the button, probably part of it was underneath of her leg, and that's probably what shielded all of the, sorry to be so graphic, but the blood and all of that, it might have shielded that from it, and that's why it was preserved. It says law enforcement seized the K-bar knife sheath pursuant to a search warrant. So they got a search warrant. That's why they got the sheath. The Idaho State Police Lab in Meriden, Idaho located DNA on the K-bar knife sheath. So the Idaho State Police Lab located DNA on the K-bar knife sheath. The ISP laboratory determined the DNA came from a single source and that the source was male. Once law enforcement had a single source DNA from the K-bar knife sheath, they conducted what is called a short tandem repeat analysis. STR DNA analysis involves looking at 20 regions within human DNA and allows law enforcement to make a direct comparison between 2 SDR DNA profiles. Law enforcement submitted the SDR DNA profile obtained from the K-bar knife sheath to the Combined DNA Index System, which is CODIS, a database of STR DNA profiles from convicted offenders, arrestees, and crime scene evidence to identify the source of the DNA. No match was found. That's because Bryan was not in the system. He didn't have his fingerprints taken. He just wasn't in the system for being under arrest for anything. Unable to find a match using STR DNA analysis, law enforcement decided to use investigative genealogy to find a lead. Genetic genealogy allows individuals to trace their lineage or connect with unknown family members using DNA. Typically, it involves sending a DNA sample, such as a tube of saliva, to a genetic genealogy service like Ancestry.com or 23andMe. The genetic genealogy service then creates a single nucleotide polymorphism profile to use for genealogical purposes. A SNP profile is different than STR-DNA profile and is used more often for genealogical purposes. The genetic genealogy service then uses an algorithm to compare the user's SNP profile to SNP profile submitted to the genetic genealogy service by other users to determine ancestry and potential relatives. The genetic genealogy service shares with the user a list of potential relatives, and depending on the specific genetic genealogy service, personally identifying information on those individuals, like their name, email address, and the amount of DNA the user shares with the potential relatives. The user does not receive any genetic information pertaining to other database users, i.e., user DNA profiles are not shared with each other. The same process used frequently by members of the public can also be used by law enforcement as part of their investigation, a technique referred to as investigative genetic genealogy, or IGG. Once a publicly available genetic genealogy service shows law enforcement potential relatives of the suspect, law enforcement applies traditional investigative and genealogical methods to build a family tree in an effort to follow the tree to the suspect or a close relative of the suspect. Family trees can be used to narrow down a potential suspect based on factors such as age, gender, opportunity, known physical characteristics of the suspect, etc. In this case, investigators used IGG to begin the process of developing a lead to the individual who left DNA on the K-bar knife sheath. The Idaho State Police utilized a private laboratory to develop an SNP profile from the DNA on the K-bar knife sheath. The private laboratory started using genetic genealogy to develop a family tree, but after law enforcement decided the FBI would take over, the private laboratory ceased its efforts and sent this SNP profile to the FBI. So maybe that's when they sent it to the one in Texas. I'm not sure. We don't know that for sure yet, though. The FBI uploaded the SNP profile to one or more publicly available genetic genealogy services to identify possible family members of the suspect based on shared genetic data. The FBI could then view through the genetic genealogy service portal information regarding potential relatives of the suspect who left DNA on the K-bar knife sheath. Based on information the FBI could see in the genetic genealogy service portal, the FBI went to work building family trees of the genetic relatives to the suspect DNA left at the crime scene in an attempt to identify the contributor of the unknown DNA. The FBI built the family tree using the same tools and methods used by members of the public who wished to learn more about their ancestors. For example, the FBI consulted social media, viewed vital records such as birth and death certificates, and viewed other information already contained in the user portal for the genetic genealogy service, including unverified information submitted by other users of the genetic genealogy service. The FBI also consulted subscription-based databases available to law enforcement for information on individual people. The product of the genealogy conducted by the FBI was a family tree that contained the name, birth date, and death date, if applicable, of hundreds of relatives, as well as their familial connections between each other and the suspect, Bryan C. Kohberger. The FBI then sent to local law enforcement a tip to investigate defendant. Okay, let me grab my drink. Yeah, it was found on the bed underneath Maddie's leg. Okay, yeah, I can tell you guys again exactly. We're on page 5. Let me go back up. I just don't want to miss our page, so. I can't remember what page it was on. I think it was on like the first or second page, actually. Here it is. Okay. So it says right here, law enforcement found a K-bar knife sheath on a bed next to the bodies of Madison and Kaylee. The sheath was face down and partially under both Madison's body and the comforter of the bed. So it was, yeah, so it was partially, so the buckle, I'm thinking like the buckle of it would have been face down underneath of her, maybe her leg, her back. I mean, it says her body, so. But I was thinking when I was envisioning the first time when we got the probable cause PCA, I was envisioning it underneath of her leg partially. But it was her leg, so I don't know. This is her body, so. And then there's some more too that'll be coming up that's pretty compelling. It's like I have to. We'll come up upon the word. There's about 27 zeros afterwards. That's all I know. I had to look it up because I was like, I've never seen a number that big before. So it says here. The product of the genealogy conducted by the FBI was a family tree that contained the name, birthplace, and death date, if applicable, of hundreds of relatives, as well as their familiar connections between each other and the suspect, Bryan C. Kohberger. The FBI then sent to local law enforcement a tip to investigate defendant. The IGG process pointed law enforcement towards defendant, but it did not provide law enforcement with substantive evidence of guilt. The FBI did not, for example, conduct a direct comparison between the SNP profile from the K-bar knife sheath and the defendant's SNP profile. That type of direct comparison required the more traditional STR DNA analysis, which was conducted by the Idaho State Police, not the FBI. Prior to the FBI's IGG efforts, the ISP laboratory developed the traditional STR DNA profile from the DNA found on the K-bar knife sheath. After identification of defendant, law enforcement recovered trash from the home of defendant's parents, and ISP laboratory did STR DNA analysis of items from the trash for comparison to the unknown crime scene DNA. The comparison indicated the DNA found on the trash belonged to the biological father of the individual who left the DNA on the K-bar knife sheath. Pursuant to a search warrant, law enforcement then collected DNA from defendant via a buccal swab. So that's a direct, like when you do a buccal swab, that's direct. A traditional STR DNA comparison was done between the STR profile found on the K-bar knife sheath and defendant's DNA. So they're doing a direct match there, no daddy involved. The comparison showed a statistical match. Specifically, the STR profile is at least 5.37 octillion times more likely to be seen if defendant is the source than if an unrelated individually randomly selected from the general population is the source. So 5.37 octillion. That's 27 zeros. If you're in the UK, I think it's 48 zeros. Isn't that crazy? I bet Banfield is having a ball. She's probably... Her people are probably running to her right now going, oh my God. Oh my God, we found something, Banfield. We've got something we can talk about. It's an illegal document. You know, I mean, it's factual. We haven't gotten anything new in a long time, so I'll take it. But it makes me feel a little bit better knowing that I think they got the right guy for sure. So I'm going to read that sentence again. The comparison showed a statistical match. Specifically, the STR profile is at least 5.37 octillion times more likely to be seen if defendant is the source than if an unrelated individual randomly selected from the general population is the source. Oh, thank you so much for gifted memberships. Oh, thank you, Mary Beth. That was so sweet. Thank you. And thank you guys all for being here. I really appreciate it. If you guys wouldn't mind just taking a second to hit the like button, it sends it out to the algorithm, and it'll help people come in and learn more about the case, more about these documents that just came out. So here it says the genealogy conducted by the FBI resulted in a lead that pointed law enforcement to defendant, but it did not result in the creation of many documents or records. Much of the information relied on by the FBI was only viewed through the user portal by the publicly available genetic genealogy services and other investigative databases. The FBI did not download or create copies of those records. Once defendant was in custody, the FBI removed the SNP profile from the genetic genealogy service pursuant to the United States Department of Justice interim report for forensic genetic genealogy, DNA analysis, and searching. This means the FBI no longer has access to view much of the information it used to create the family tree and cannot view it again without resubmitting the SNP profile to the genetic genealogy service. To the state's knowledge, the only record that reflects the FBI's efforts to create defendant's family tree is the family tree itself. Notes jotted down by the FBI agents as they constructed the family tree, and any records created to document the removal of the SNP profile from the genetic genealogy service pursuant to the DOG policy. The state has not seen, nor does the state possess these records or copies of these records. Now we're going to get down to the argument. The state seeks a protective order for a narrow category of information, namely information related to the use of IgG in this case. Idaho Criminal Rule 16 governs discovery in criminal proceedings, State v. Ish 16 Idaho 492 510 2020. Rule 16 is broad, but it is not a free-for-all. The rule contemplates the exchange of discrete categories of information between the state and the defense. As relevant here, the rule contemplates the state will provide 3 discrete categories of information. Any material or information that would tend to negate the guilt of the accused, any documents or objects that are material to the preparation of the defense, intended for use by the prosecutors as evidence at trial, or were obtained from the defendant or belong to the defendant. And reports of scientific tests or experiments. It says, if the defendant believes he should receive information that does not fall within one of the discrete Rule 16 categories, the rule allows the defendant to seek an order from the court for information where the defendant can show a substantial need for the information in the preparation of his case. It says here, defendant served on the state a request for discovery that calls for the IgG information, even though the IgG information falls outside the rule of Rule 16, without first obtaining an order from the court. The state now seeks, and the court should enter an order protecting the information related to the use of IgG in this case. Specifically, the state seeks to protect the following information: the raw data related to the SNP profile and the underlying laboratory documentation related to the development of the profile, such as chains of custody, forms, laboratory standard operating procedures, analyst notes, etc. All information related to IgG efforts in creating a family tree and identifying defendants' potential relatives, including the identities of the genetic genealogy services and the personally identifying information of defendants' relatives. The state does not seek to protect and has or will disclose the following information: a genotype kit report from the private lab utilized by the Idaho State Police, which documents that a DNA test was performed; information related to the STR DNA analysis conducted using the DNA recovered from the K-bar knife sheath and the DNA recovered from the defendant's parents' trash; information related to the STR DNA analysis conducted using the DNA recovered from the K-bar knife sheath and the DNA recovered from the defendant via a buccal swab. This court should grant an order protecting the IgG information in this case because the IgG information does not fit into any of the discrete categories listed in Rule 16, and good cause exists to protect the information, including the need to protect the privacy of defendants' relatives. It says A, Rule 16 does not require the disclosure of the IGG information because the IGG information is not exculpatory. Rule 16 of the Idaho Criminal Rules does not require the disclosure of the IGG information because the IGG information does not tend to negate the guilt or reduce the potential punishment of defendant. The rule requires the state to disclose any material or information in the prosecuting attorney's possession or control that tends to negate the guilt of the accused as the offense charged or that would tend to reduce the punishment for that offense. As written, this rule largely mirrors the federal Brady requirement that the state produce to a criminal defendant all material exculpatory information. But Rule 16A and Brady are limited to exculpatory information. They do not require the prosecutor to make a complete and detailed accounting to the defense of all police. I'm sorry, let me read that again. I got mixed up. They do not require the prosecutor to make a complete and detailed accounting to the defense of all police investigative work or on a case. Investigative work. I can't say that word. Work on a case. While the question of whether IGG information must be disclosed as exculpatory is one of first impression in Idaho, courts outside of Idaho have correctly decided that IGG information need not be disclosed as exculpatory. Ruling on motion to compel produce or of discovery attached hereto as Exhibit A. In Green, law enforcement used DNA recovered from the victim's nightgown to identify the defendant as a possible suspect. So C, Green, opposition 2. Then they surreptitiously recovered items from the defendant's garbage that contained DNA and found through STNR DNA testing that the DNA in the defendant's garbage matched the DNA found on the victim's nightgown. A saliva test then confirmed that the defendant's DNA matched the DNA on the victim's nightgown. The defendant moved to compel the disclosure of the IGG information. After an in-camera hearing, the court denied the motion. So they denied the motion. This is why for that case. The court explained the evidence that is material to the defendant's guilt or innocence is the testing that followed the IGG investigation, which directly compared a fresh swab of the defendant's DNA with the DNA profile collected from the victim's nightgown. It is only this evidence that the people tend to present at trial. The people are not obligated to provide its preliminary search of the genealogical database for possible matches, which is investigatory in nature and is not exculpatory or material to the defendant's defense. So basically what they're saying is they don't need to use the genealogy crap. They went ahead and they got a direct match from the knife sheath to the buccal swab they took from Bryan Kohberger. They matched those two things up. So they don't even need his dad's, Michael's DNA anymore. They don't need the genealogy. That's why they were throwing it out. That's why they didn't care about it. Yeah, they're referencing another case. Hey, Mandy. But that's why, they kept saying, we were hearing that they're not going to use the genealogy. They're not going to use the genealogy. We're like, well, why aren't they going to use the genealogy? Because they have direct DNA. They don't need that petty crap. Now, I did forget to write down exactly, but it was like 5.37 octillion. Octillion, that's 27 zeros, that it's Bryan C. Kohberger. Bryan Kohberger. They had a warrant, these Smalls. They did. We just read it. They had a warrant. They had a warrant for his DNA. They had a warrant for the trash. They had a warrant for the knife sheath. They had a warrant for all three. Yep. They sure did. Let me grab my vape real quick and then we'll get back to reading. Because I have read a lot today, guys. We read, if you weren't for our live earlier, we read 43 pages of the worst thing I've ever read. The worst of the worst for the Harmony Montgomery case. So then it says, as this case illustrates, the state is not required to disclose the IGG information under Rule 16 because the IGG information the state seeks to protect is not favorable to defendant on the issues of guilt or punishment. The information provided to local law enforcement by the FBI was nothing more than a tip, a lead for local law enforcement to follow up on should they choose to. The genealogical tip did not prove or sustain defendant's guilt. or substantiates the defendant's guilt. Rather, the tip allowed local law enforcement to focus their investigation on defendant and obtain independent material evidence of his guilt, all of which the state has disclosed or will disclose. Specifically, with respect to DNA and STR DNA analysis, found defendant's DNA matched the DNA collected from the K-bar knife sheath. So defendant's DNA matched the DNA collected from the K-bar knife sheath. To the extent the IgG information has any relevance, the fact that it led law enforcement to defendant means it is inculpatory rather than exculpatory in nature. Thus, Rule 16 does not require the disclosure of the IgG information because it is not relevant to and certainly not favorable to the defendant on the issues of guilt or punishment. Number B, Rule 16, Section B, Section 4, does not require the disclosure of the IgG information because the IgG information does not satisfy any of the required criteria. The nature of the IgG information is such that its disclosure is not required under Rule 16, Section B, Section 4. That rule requires the disclosure of books, papers, documents, photographs, tangible objects, and buildings, or places only when they, 1, are material to the preparation of the defense, 2, are intended for use by the prosecutor as evidence at trial, or 3, were obtained from the defendant or belong to the defendant. The IgG information does not satisfy any of these criteria. First, the IgG information is not material to the preparation of the defense. Defendant is charged with killing 4 people, not with being related to a particular person. The mere fact that uploading the completed SNP profile into a publicly available genetic genealogy service led law enforcement to relatives of defendant does not affect the strength of the evidence against him. The strength of the evidence against defendant in terms of DNA evidence depends upon the confirmatory results from the STR DNA analysis between defendant DNA profile and the DNA recovered from the K-bar knife sheath. As explained further below, the state intends to introduce the STR DNA analysis at trial and does not intend to enter any evidence pertaining to the development of SNLP profile or the tree building process for inculpatory purposes. The state has disclosed or will disclose the information it has related to the STR DNA analysis conducted in connection with the case. The immortality of the IgG information of the preparation of the defense is perhaps best understood by way of analogy. The tip that came from the IgG process is no different than other types of technology hits that put law enforcement on the trail of a suspect. It gives a little thing here. For example, okay, so this is the United States versus Johnson. For example, in Johnson, law enforcement recovered a suspect's DNA from a ball cap left at the scene of a bank robbery. Law enforcement ran the DNA profile through CODIS, which resulted in multiple hits, including the defendant's. A scientist narrowed down the hits to a defendant, and law enforcement confirmed it was the defendant's DNA after acquiring a buccal swab from the defendant. The defendant moved to compel the other CODIS hits from the government, but the court denied his motion. The court explained the DNA evidence material to the defense was a direct comparison between the DNA on the hat and the DNA taken directly from the defendant. The fact defendant was first identified as a possible suspect based on a database search simply does not matter. Here, the IgG information, like the initial CODIS hit in Johnson, is not material to the preparation of the defense because it only shows how defendant was first identified as a possible suspect. Moreover, the IgG information could not support an argument from defendant that law enforcement violated his Fourth Amendment rights by entering the DNA collected from the K-bar knife sheath into a genetic genealogy service. A defendant cannot prove a violation of the Fourth Amendment, and that's unlawful search and seizure, I believe, isn't it? Yep. Without first showing he or she had a reasonable expectation of privacy in the first place. Okay, privacy in the place searched. The K-bar knife sheath was abandoned at the scene, as was the DNA inside it. Defendant cannot show that he had a reasonable expectation of privacy in DNA left at the scene of a quadruple homicide or in the genetic information of his relatives who voluntarily provided their DNA to a genetic genealogy service. It's like one of them, sorry guys, Can't take it back. It's not yours. He's over here saying I own the DNA. Give it to me. Oh, thank you. Be happy for the super sticker. That's so sweet. Thank you. Did I miss somebody? Was that from earlier? I think that was from earlier. I don't want to miss anybody. So let's see. Where were we at? Down here. Holding defendant's DNA did not have reasonable expectation of privacy in water bottle from which officers recovered DNA and observing that this court... Did I miss something? No, Oh, this is another one. Okay, sorry. See Perio versus state. And then it's the Idaho. So it says holding defendant did not have reasonable expectation of privacy in water bottle from which officers recovered DNA and observing that this court has found no case holding that a reasonable expectation of privacy should be determined by a suspect's desire to keep his or her genetic DNA identity private. Additionally, the sheath and defendant's DNA left on the sheath were seized pursuant to a valid search warrant issued by a magistrate judge, which means the law presumes that the search was reasonable. State versus Hutton, they're giving another one. When a search is conducted pursuant to a warrant, the burden of proof is on the defendant to show that the search was invalid. Second, the state did not rely on the IgG information to establish probable cause for the defendant's arrest, did not present the IgG information to the grand jury. So I'm going to read this again. So, second, the state did not rely on the IgG information to establish probable cause for the defendant's arrest. It did not present the IgG information to the grand jury and has no plans to present the IgG information for which a protective order is sought as evidence at trial. Instead, the state has relied on and will continue to rely on the STR DNA analysis comparing defendant's DNA to the DNA on the K-bar knife sheath to establish defendant's guilt. Again, the state has disclosed or will disclose information related to the STR DNA analysis conducted in connection with this case. Third, the documents and tangible objects encompassed in the IgG information were not obtained from the defendant and defendant has no property interest in them. To the extent the DNA on the K-bar knife sheath once belonged to the defendant, he abandoned that DNA when he left it at the crime scene of a quadruple homicide. Defendant has never had a property interest in the records that reflect the SMP profile developed from the DNA on the K-bar knife sheath, nor has he ever had a property interest in the information gathered from the genetic genealogy service using SMP profile, such as information provided to the genetic genealogy service by defendant's relatives. In short, none of the IgG information the state seeks to protect came directly from defendant or currently belongs to defendant, and thus Rule 16b-4 does not require its disclosure. Rule C does not require the disclosure of the IgG information because the IgG information is not the result of a scientific test or experiment. Rule 16 also requires the disclosure of information related to scientific experiments, but only applies to limited information. Namely, Rule 16 requires the disclosure of results or reports or scientific tests or experiments made in connection with the particular law. ICR 16, Section B, Section 5, emphasis added. The rule does not require the state to disclose what law enforcement does with the results or reports. Moreover, a process, procedure, or investigative technique is not a scientific test or experiment merely because it involves the comparison of information or objects or requires the use of logic or reason. See State v. Matthews. Holding an officer comparison of two keys did not constitute a scientific test or experiment because it was merely an observation of similarity between the two keys. The two types of scientific tests conducted with respect to DNA that fall within the preview of Rule 16b-5. First, law enforcement used STR DNA analysis to compare the DNA on the K-bar knife sheath to DNA's father and then to defendant. As required by Rule 16b-5, the state has provided the reports from those scientific tests. The state also provided other information related to the STR DNA analysis because the state plans on using that information at trial. Second, the private laboratory developed the SNL profile from the DNA on the K-bar knife sheath. Oh, no, sorry. I was just seeing if Banville was talking about this. Second, the private laboratory developed the SNP profile from the DNA on the K-bar knife sheath. As required by Rule 16.5 or B5, the state will produce the report that documents the DNA test. Rule 16b5 does not require the state to disclose how the SNP profile was used in the genealogy the FBI conducted based on the DNA information does not constitute a scientific test or experiment. The FBI submitted defendant's SNP profile to one or more genetic genealogy services and were able to view potential relatives and access unverified data added by users in the genetic genealogy services. Starting with those potential relatives, the FBI engaged in traditional genealogy to put together a family tree that could lead them to a suspect. Putting together the family tree required the FBI to review sources such as social media, publicly available databases, subscription-based databases, vital records like birth certificates, census records, and historical newspapers. None of those actions can accurately be categorized as a scientific test or experiment. That's true. The product of the FBI's efforts was a family tree comprised of hundreds of defendants' relatives. Put simply, the family tree created by the FBI cannot accurately be described as the results or reports of scientific tests or experiments, and thus falls outside the Rule 16b5. D is good cause exists for the court to enter an order protecting the IgG information, and if necessary, the court should hold an in-camera hearing. The mere fact that the IgG information does not fall within Rule 16 is reason enough for this court to enter an order protecting the IgG information, but the state is not seeking the protection of the IgG information as an exercise in abstinence. I haven't even said that. That's bad, guys. Instead, the state seeks to protect hundreds of innocent civilians from having their personal information, including their names, birth dates, and familial connections to the defendant in a high-profile quadruple homicide from being disclosed. The disclosure of the IgG information risks harm not only to those indirect informants, but also to the genetic genealogy service used by the FBI and the IgG investigative technique. This court should follow the procedure laid out by Idaho appellate courts to determine whether the IgG information must be disclosed. One, providing the IgG information would require the disclosure of the identity of informants and prejudice of the state. So that's maybe who they're referring to when they're saying informant. They might be talking about I need a breather. Let's see. I want to see. Okay. The process used to collect IgG information required gathering information from several informants, including the genetic genealogy service to which the SNP profile was submitted, and indirectly from the relatives of defendant who hit on the SNP profile, pursuant to Rule 16. Disclosure must not be required of the informant's identity unless the informant is to be produced as a witness at a hearing or trial. The state has no intent of presenting the IgG information for which a protective order is sought as evidence at trial, which means none of the IgG informants will be produced as witnesses at trial. The non-disclosure of this information is consistent with the state's privilege to refuse to disclose the identity of a person who has furnished information relating to or assisting in an investigation as of a possible violation of a law to a law enforcement officer. Is everybody doing okay in the chat? I haven't looked over there for a while. You guys, everybody okay? Everybody got water, drink, soda, something, beer, wine? We're like halfway done. More than halfway, I think. They do DNA. Yep, with the family. Whew. Lord have mercy. No, not really, Nancy. You're not doing good. Oh, whatever it is, just let me know. Let me know, and I'll do it. Just put it in bold. You know how I am. Andy said, I'm glad I don't have to read this. This is the second document I've read today, so forgive me if my words are not there tonight. We read 43 pages of a PCA today. I did, Cheryl. I read a lot. And yeah, but I was like, I have to read this to you guys tonight. So I couldn't not wait. So this was too good. It was just too much information was there. And I'll do a recap at the end, of course, too. So, let me see. I think it's right here. As a general matter, we protect the identity of informants. The U.S. Supreme Court has explained to encourage the flow of information concerning the commission of crimes to law enforcement. McGray versus Illinois. Such communications are discouraged if the informer's identity is disclosed. The court words, written long before S&P profiles were used for investigative purposes, apply with particular force to IgG information. Both the genetic genealogy services to which law enforcement agencies submit a suspect's S&P profile and the customers of those genetic genealogy services who may unknowingly be related to a suspect would be less likely to make their information available if the courts start requiring the disclosure of their information in criminal cases, especially in high-profile criminal cases. Yeah. Protecting IgG information in part because the court retains a wide discretion to protect against the disclosure of information that might unduly hamper the prosecution or violate some other legitimate governmental interest. Number 2, the court should follow the process laid out by Idaho appellate courts to determine whether the IgG information must be disclosed. Rule 16 allows this court to enter a protective order for good cause if the court finds it necessary to review evidence in camera to decide whether disclosure is required. The rule itself allows the courts to do so. The court expressly contemplates that in deciding whether to enter a protective order, the court may permit a party to show good cause by a written statement that the court will inspect ex parte. If relief is granted, the court must preserve and seal the entire text of the party's statement. Thus, Rule 16, standing alone, provides the court with the tools it needs to review evidence in camera if the court decides it cannot enter a protective order based on this brief alone. Idaho appellate courts have further explained the process district courts should use when faced with precisely this issue. They need to protect both the state's interest in non-disclosure of the identity of its informers and defendants' right to receive exculpatory information. See State v. Wilson. In Wilson, for example, the court explained that the situation calls for a two-step process. First, the defendant must make a threshold showing that the informant may be able to give relevant testimony. Wilson, 142, Idaho, at 435. If the defendant successfully makes that showing, an in-camera proceeding then provides an opportunity for the state to show that informant's knowledge is not of such relevance that disclosure should be motion for a protective order. Oh, I'm sorry. I thought that was just a say. I'm sorry. I thought it was this. That's the thing that we're reading. Sorry. That disclosure should be ordered. See also State versus Forlow. Relying on Wilson to explain this same two-state process, once this, man, okay. Let's take a break. I'm mixing my words up. Once the trial court has concluded the defendant meets the initial threshold showing, it must then conduct the in-camera examination. Further, the Idaho Supreme Court has confirmed that it is desirable and proper to hold such an in-camera hearing before ordering or denying disclosure. State versus Hosey, man, they're giving us a lot of examples. Even if the court finds that the IgG information falls within Rule 16, this court should follow the guidepost that Idaho's appellate courts have planted for the protection of informants. Defendants should first be required to establish that the IgG information is in fact relevant to the charges against him. If he can do so, the court should allow the state to present information at an in-camera hearing for the court to determine whether the IgG information must be disclosed. Wilson, 142, Idaho, 435. Explaining the in-camera presentation ordinarily may be made in the form of affidavits, but allowing the trial court to examine witnesses as well as the trial court deems if necessary. In conclusion, based on the above, the state respectfully prays for the court to enter an order protecting the IgG information from disclosure as it falls outside the preview of Rule 16. In the alternative, if the defense can establish the IG information is in fact relevant, the state asked the court to conduct the requisite in camera hearing for the state to present information related to the IG information and then enter a protective order under ICR 16. That the IG information is not subject to discovery and need not be disclosed by the state. What? Did we miss something? Okay, what's this? Maybe this is, I think this is just the, I think that these are the different cases. Let me see. Is this doubled? I think this is doubled. No, it's not. These are just like, I think these are examples that they're giving us right here. Oh, there's Vincent. Oh, that's really sweet. Yeah, these are just different. It looks like just different. They're giving different examples. Let me see what this other one is. Yeah, these are just statues. Okay. I was just making sure none of this was. Yeah, this is the case from Ohio. Yeah, so this is like the examples that they were giving. Okay, I was just making sure that we didn't miss anything there. So, sorry if I gave you guys a little bit of a headache there when I was going down the, going back and forth, like scrolling back and forth. But, yeah, please like and subscribe and share this channel along, like Teresa said. I have no idea what my phone said. Well, earlier I was reading something. We were reading the PCA and my watch just said something. Like she just was talking and it scared the crap out of me. Like, I'm probably going to have oh my Lord, I'm going to have nightmares tonight about both of these guys. I've got the guys and bad guys in my dreams. So, okay. So they, I was going to try to find the actual number so that I can get it correctly because I don't want anyone to, I think it was 5.37 octillion. That it's Bryan, yeah, right here. So they did, so, okay, they did the genealogical testing. So they did where they did through his family tree. They said that they had hundreds of his family members. So I don't know how far back in that family tree they went, but they were back there to where they had to, eventually they called up to, Michael Kohberger, Bryan Kohberger. Well, they got Bryan Kohberger because they got the, the DNA out of the trash can. That was his father's. Well, we've been hearing lately that they are going to not use the genealogical DNA in the trial, and they didn't take it to the grand jury. And we're like, well, what? Well, why not? We thought that's our bread and butter. So we've been kind of like, well, they must have something else, right? Well, they do. They have a DNA direct match. So directly from Bryan Kohberger's cheek to the button swab on the knife sheath. And the knife sheath was found partially under Madison Mogen's body, and it was upside down, and it was turned upside down. So it was facing down. They took the DNA from the knife sheath. They took the DNA from Bryan Kohberger, and they ran a test. And that test came back and it said statistical match. The STR profile is at least 5.37 octillion times more likely to be seen if defendant is the source than if unrelated individual randomly selected from the general population is the source. And that's pretty much him saying your cousin's friends, sisters, brothers, nobody that's related to you twice removed. It can't be them. Unless he's got a twin rolling around here we don't know about. A Kohberger twin. Oh, ATS News, when I read this, I was all up in this today. I was like, we're going to read this tonight. Because, and it did say that the knife sheath was found underneath. I'll go back up to that part too, because that was in the beginning. And I know a lot of people didn't hear the beginning with this. So they said the sheath was face down and partially under both Madison's body and the comforter on the bed. Law enforcement seized the K-bar knife sheath pursuant to a search warrant. They had a search warrant for the garbage, they said. They had a search warrant for the DNA on the K-bar knife. They had a search warrant for the K-bar knife. So they literally had all their ducks in a row. So, yeah, who's fighting? What's going on? What's happening? What do I see? What's going on? Do I need to get someone? Oh, maybe that's why Vincent was in the chat. Oh, don't make him come out. He just put a smiley face. Where's he at? Now I gotta go back up and find him. Put another smiley face. Oh, wait, I gotta go up on this side. Hold on 1 second. 1 second, guys. Sorry. Where's he at? Okay. I don't really know. What's the difference between what's the difference between a managing moderator and a regular moderator? I don't know. I'm still waiting on the trial. I have to hear both sides. Yeah, no, for sure. I'm ready to hear what the defense is going to be pulling. I'm ready to hear it all. But man, oh man, did he fudge up. Because I'm sorry. But, I mean, how else did the knife sheath get there? And nobody say it was a party and he walked in with it on his belt. Because, I mean, come on. Nobody's walking around with a freaking K-bar attached to their hip like that. And for it to be underneath of her? Ooh. I wonder if he knows. Wonder what he knows. Because he looked pretty confident in court. So Aristocat, what I think happened was and this is what I've been saying all along. I thought the knife sheath was partially underneath Maddie's, this is me, it says body, but I thought leg and the comforter. The way that this says, it says that it was upside down. So that would have been protected by the bed. And then her body on top of it would have protected whatever that was right there. If that makes sense. I mean, whatever was, left out hanging, I'm sure that got stuff all over it. But whatever was underneath of her body protected the weapon from getting anything on it. Because they were no longer moving, they couldn't, get blood on it. Gonna look pretty confident in front of the firing squad too. Sorry, that made me laugh. I didn't mean to laugh at that, but that made me laugh. I wonder when he, so like allegedly, 5.37 octillion. But when do you guys think he noticed that he didn't have the knife sheath anymore? Because you think you're, going to I don't, I always thought he was going back upstairs to grab the knife sheath, and that's when Dylan saw him and he walked out. Then he walked back down and he walked out the front door. That's me. I'm the front door gal. I'm just a weird person. But that's what I think happened, was he was trying to go back up there to get it. I think that after he was finished, he was like going to put his knife away, and then he was like, well, shit, how am I going to put my knife away? I ain't got my sheath. Yeah, you put your knife right back. Yeah, you would think true crime and other stuff. That's what I would think. You would think after the last victim, he was. I mean, shit. You would think after. If Maddie and Kaylee were first, let's say, you would think he would put it back after that. But I guess maybe he wanted to stay armed just in case somebody came, in front of him. He probably just ran out and didn't even, because it was so fast. Anyway, either way. I don't know why she didn't see the knife. Maybe she might not have been looking down. She might have just been looking up and just didn't even, just stunned. Yeah, and maybe didn't know he lost it till he's leaving. Yeah, maybe he noticed, when he's seen the crime. Yeah, I saw that little video, Farah. I saw that. Hi, Mystical Keeper. I like that name. That's cute. And your picture looks like it's fun, too. Let me put it up here. Oh, that is fun. So, I was shocked when I read these today. I was like, what? Yeah, I can reread where the sheaf was. Yep. I can actually see it right now. So, it says here... Let me find it. Actually, you know what I'm going to do? I'm going to read you the PCA, the first PCA, because that's what we did in the beginning of the live too. And I'm going to read you what it says now. So, in the PCA, it says, I also later noticed what appeared to be a tan leather knife sheath laying on the bed next to Mogan's right side. The sheath was later processed and had K-Bar USMC and the United States Marine Corps Eagle Globe and anchor insignia stamped on the outside of it. So now the factual background, comes out this motion today, and it says, right here, law enforcement found a K-Bar knife sheath on a bed next to the bodies of Madison and Kaylee. The sheath was face down and partially under both Madison's body and the comforter on the bed. So if you were just to be laying right on top of it. I'm reading your comments. It's just insane. It's, wow, Oh, actually, you know what? Let me see if I don't know if I put it under, this looks funny in the chat, then I have to redo it, because I thought I put your name in there, but I might have put it under the whole thing. Let me see. Oh, look, I did do it. Did I do that right, ATS News? I hope I did that right. I tried to get you in my Nightbot. I was like, she's so sweet. I need to put her in there. But yeah, so they, I don't know. This is a lot to take in. They did have, let's see here. The state responded to the fourth, we read earlier, the defendant's fourth supplemental request for discovery. These are just real short documents, so we'll go through them kind of quick. But it says, to the defendant, Bryan Christopher Kohberger, and counsel Ann Taylor. Comes now the state of Idaho by and through the Latah County prosecuting attorney and submits the following response to defendant's fourth supplemental request for discovery. The state incorporates its January 23, 2023 state's response to request for discovery, February 21st, 2023, state's response to defendant's first supplemental request for discovery. March 29th, 2023, state's response to defendant's second supplemental request for discovery. May 12th, 2023, state's response to defendant's third supplemental request for discovery. May 12, 2023, state's response to defendant's motion to compel discovery. And June 8, 2023, state's supplemental response to defendant's first, second, third, and supplemental request for discovery. As if fully set forth at this point, the state will and continue to provide discovery in accordance with ICR 16 and applicable law. So they're just saying, like, we're giving it to you. You know, we're giving it to you. And then stage response here for the amended motion to stay. It says, comes now the state of Idaho through Latah County prosecuting attorneys in response to the defendant's amended motion to stay proceedings filed herein on June 5th, 2023, by incorporating as if fully set forth at this point the state's initial objection to motion to stay proceedings previously filed on June 15th. And now he does have a court date coming up. I believe it's the 27th. And then the other one is just a, they just want to keep it under seal. Let me see. It just says Bryan Kohberger through his attorney hereby is the court for an order to file Exhibit C of defendant's fourth supplemental request for discovery under seal. This motion is made pursuant to ICAR 32, Section A, Section 2, Section D, Section E, and IC 74-124, Section A, Section B, Section C, because one, the documents contain facts or statements that might threaten or danger the life or safety of individuals. 2, it's necessary to preserve the right to a fair trial. And 3, disclosure would constitute an unwarranted invasion of personal privacy. And that is them. Did we get this one? Yep, that was the last one, so. Good golly. We did it, guys. I've got like so many tabs open, it's not right. So man, wow. Oh my, I know, I'm Avery. We did the Harmony, I did the Harmony PCA before this. That's why I was almost out of breath reading that document. So I read 43 pages earlier, and then that was 33, I think. But then we didn't do some of them, so it was like 20 something. So yeah, we've read today on this channel. We've done our reading. If you haven't seen the Harmony video that we did earlier on it, we did a live on the PCA. If it's something that you can handle hearing, we do have it on the playlist for Harmony, and it's just under the live. So if you want to check that out, we did read through that today and discuss it. But I don't know. So who would plant? So so the people that said that the knife sheath was planted, why? Like, why was it planted? And who planted it? Oh, thank you, Be Happy. You're welcome. Thank you for being here. I appreciate it. Thank you, everyone, for being here. And I didn't even put, this whole time I forgot. If you guys wouldn't mind, liking the video, that really helps a girl out. If you want to join our channel membership, I just put the link in there. We'd love to have you. Why would Bryan be there? Yeah, that's a good question. Corporal who? I mean, I think they were just fighting for dear life, and Maddie, she might. I mean, she's feisty. She probably, just ended up. She probably ended up just like laying on top of it. That's where it ended up being, and it was probably a little bit more than what he anticipated, because nothing can prepare you for what he did. I mean, for allegedly what he did, for whatever was happened to these kids. Whatever happened to these kids, nothing can prepare you. I went to school for criminal justice and applied science, just like Kohberger's doing, and no crime scene photo, no amount of essays, no amount of legwork, no amount of anything is going to prepare you for what happened to those kids. And the reason why I believe there's not a lot of blood trail like out of the home and stuff of that nature is because maybe he shut the doors after he did what he did. And then, you walk around the house a few steps and it's going to kind of come off your shoes. And then maybe he walked outside. I think that there's some stuff maybe that was outside that we didn't see that they got, that the officers saw. They took pictures and stuff. I think that they could see it with their eye, but maybe we couldn't see it with ours. So yeah, maybe pulled over. Yeah, pulled off in the tussle. Christina, you might be right. Maybe whoever, like, okay, maybe if, let's say Kaylee was fighting with him or something. Maybe she saw that sheath and she was thinking it was like a gun holster or something of some sort. Do you know what I mean? I don't know. I would think that. If I saw like a sheath of some sort, I would think that was like because I mean, I'm just like, I've never seen anybody walk around with knives. I've seen people with guns. Yeah, totally possible. I think that's how I did ATS News. I really do. I think that it was during the scuffle and he just wasn't prepared to, for what he was doing. And he just was like, okay, I've got to go on about my day. Like I got other things to be doing. No, not in this report, Avery. No, not yet. We haven't got that back yet. Nothing about the car. And even if you wipe your brake off, and let's say you wipe off that little silver lever, that there's underneath of your brake, there's bolts, there's screws, it would be really hard to not have some sort of trace in the car somewhere, I would think. Maybe that seatbelt boot that they took, I'm not sure, but we'll know in due time. He is right-handed, but he writes funky a little bit. You know how, I don't want to make fun of left-handed people because Vincent's left-handed, but that's how, so like when you're left-handed, your arm it curves in a way. It curves differently than if you were right-handed. It curves like more towards you when you write. Well, Bryan Kohberger, he writes like that. He writes like towards himself. Yeah, even the vents. Yeah, Mystical Keeper, you're right. Everything can be, yeah. I mean, they've pulled off things. Okay, they've pulled off of like leaves and stuff off of like cars, and they've been able to trace the leaves back to the tree that they came from. Like it's insane what people can do. And then if something happens where they test, the dog hair, suppose the dog hair, and it comes back as, belonging to one Murphy, then we might, I don't know. He better have answers. He better have answers, yeah. He better have some. And that's another thing. Why, I mean, I said this on the other night on the live, but why if his daddy, and I'm not saying nothing about his dad, I'm not, but how come if his dad can fly out there and then drive all the way back to Pennsylvania with him, how come his family has not been there for one day of court? Like flown out there for one thing, like first day, or said something on the record, like, hey, my son is a good kid. It's crickets over there. In the Kohberger compound, it's crickets. The sister, she might know what's up, but I don't know. No alibi, yeah, no, none of that. He's trying to find one. He keeps saying, give me more evidence. I'm trying to find my alibi, guys. Come on, guys. Yeah, Leslie, that's yeah. Leslie, that's me. You're probably right. Because like I think that if somebody, I don't know, this is a horrendous crime for somebody's first time. I do think that, but that's what mass murder really is. I mean, do I think he would have done it again if he didn't get caught? If it's Bryan Kohberger, 100% I do. I think if whoever did this and they don't get caught for it, I think they will do it again. Yeah, let me find you an alibi while I'm anxious to exonerate myself. Yep, it's no different than having the genealogical, but it's a direct match, so it's a little bit. It's better because there's none of that. Well, my dad had another kid, and he's not around anymore. He's missing. You know what I mean? You can't be doing any of that. He doesn't have a twin, as far as I've seen. I mean, oh my Lord, have mercy. That'll be the next thing. Kimchi said he went for one and messed up and had to go for 2-4. Yeah. Yeah, his family doesn't have much money, Christina, but his daddy was able to afford a plane ticket out there and a drive back. But you can't go see your kid. I mean, I'm just saying, if that was my parents, I'd be throwing a fit. I would be throwing a fit. But I know me. I know my attitude. I don't like to, I'm impatient. I don't like to be put in one spot. I wouldn't be able to do jail. Jail life ain't for me. Let's see here. BK on his first also killed 4 people. Yep, you're right, Steve. You're so right. BTK on his first kill also killed 4 people. Yep. And I didn't know that until I was researching for this case. Well, I was researching them together. And I was like, wow. Because I knew a lot about BTK prior. I've seen a lot of documentaries and stuff. I think that this could have been his first crime. It was Brian's twin brother, Brad. Oh, God. True crime and other stuff. I bet you. I bet you someone comes out with it. I can just see it now. Oh, I can take these glasses off now. I had to put like glasses on tonight. Oh, I usually have my camera on and everything. I just was reading so much tonight and my eyes are burning. That's true. If your child's defense team instructed you to not say a word as it could hurt your child's case, then a parent would follow the instruction. I'm sure he's telling them to shut up. Because, I mean, if you're his defense team, like, okay, if I was a defense attorney, right, I would say, when I met my client, I would say, okay, Bryan Kohberger, what's your alibi? Like, what happened, you know? And if he tells you some crazy story, say, did you do it? Did you not do it? Just, give me the truth, because we can fight it if you did it. We can fight it if you didn't do it, but I need to know what I'm working with here. That would be me. And then he would say, I didn't do it. And then I'd say, okay. And then I'd be fighting for him. And then I'd have to go back when this DNA come up, because I'd have to be like, Kohberger, Mr. BK, you said that you weren't there, you don't know these people, but your DNA's there, so why, sir? I wonder or do defense attorneys just act like they're stupid and they're just like, oh, I don't understand how that works, but, if I was a defense attorney, I would say that. I think that Kaylee might have been, I think Kaylee was sleeping in her own room that night too. Oh, I don't know actually that Bryan didn't buy the ticket. But I'm going to say that he probably didn't buy the ticket. Usually, parents will buy them. Or I don't know, he probably said, I'm not going back. I wouldn't want to go back to Pennsylvania if I was out here. This is California where I'm at in this picture, but it's beautiful out there. Exactly, Chosen Rosen. And nice to see you. And nice to see you, Ashley. Is Summer here? Did Summer quit? I haven't seen Summer in a while. I just realized that. Is she okay? I think she's okay. She probably said I quit. No, Cheryl, she wasn't found on her. They never said that. That was somebody stating that. They were both found on the bed, but they didn't state where they were found beside each other. You think he was going to sell the car? Could have, yeah. What, Arlene? Oh, fudge. No, nuh-uh. Sorry, guys. I'm just writing her. Oh, my Lord. I didn't know that. Why didn't anyone give me the big words? The big words, guys. And if you could hear, like, it was like cutting out earlier, it wasn't my mic cutting out. It was just me muting the mic. So if it sounded a little weird, that if it was a little more than usual, it's because I was taking a hit off my vape. So if it was muted, that's why. Okay, let's see here. So tomorrow, okay, so tonight what we were going to do was we were going to watch the documentary over the Idaho 4, and it was on Amazon. I believe it was on ID Discovery. So we were going to watch that this evening, and then, you know, all these documents came out. So we'll watch that tomorrow. It's like 42 minutes long. If you guys haven't seen it yet, I haven't got to see it. So I'm not going to watch it until we can watch it together. So I will be back on tomorrow around 8, I was about to say 8:15-ish. So make sure you're here or I'll be looking for y'all. Nah. Just make sure that you do hit the like on your way out. I'm going to make sure that Summer's okay and, you know, her brother's okay. Yeah, everybody give a prayer for Summer's brother. Yeah, I didn't know. Oh my gosh. Oh, you tried? Oh, I'm sorry. I didn't see it. Oh no. I'm going to have to like do something. Thank you, Teresa, for the congratulations on the subscribers. And I got a little banner behind my head too that says that. So I'll put that down so you guys, I'll put myself down so you guys can see it. But we will do the video tomorrow. Maybe we'll do an open panel and we'll just see kind of how it goes. But I love you guys. Thank you for being here. I really appreciate it. Thank you guys for joining the channel. Oh my gosh, 9,000 Titans, guys. 9,000. We made it. If you want to join our channel membership, it is in the chat, and I will see you guys all tomorrow. Bye, guys.